For folks who don't know me, I'm Hillary Hayden. I'm the organizing director for the Trade Justice Education Fund, and we're a national organization dedicated to stopping the damage of corporate-centered trade deals and promoting a positive vision for international trade. These Trade Justice Power Hour calls happen every third Thursday at 3 p.m. Eastern and cover a wide range of educational topics about trade policy that will be relevant and interesting to activists across the country. I do want to note quickly that these calls are not intended as press briefings. So if you are a member of the press, I would love to chat with you separately, but this is not the place for those questions. By way of an agenda for today, I'm going to frame our conversation a little bit around digital trade issues and then hand the mic off first to Daniel Rangel and Katie Hettinga from the American Economic Liberties Project Rethink Trade Division to talk about their amazing research on what state laws might be impacted by these digital trade rules. And then we're going to hear from Julie Bouanna at the Washington Fair Trade Coalition about great work that she's doing on these issues in Washington State. Before the end of the hour, we're going to have time for questions, so please put those questions in the Q&A feature as we go. With that, I'm going to jump in. For those of you who have been participating in these briefings for a while, you've heard us talk many times about the threat of big tech's digital trade agenda. Really briefly, the big tech sector, companies like Amazon, Google, Facebook, and others have been pushing really hard in recent years to quietly sneak binding rules into trade agreements that would limit government's ability to enact new consumer privacy, data security, AI accountability, workers' rights, and anti-monopoly measures. These companies know that they're facing increased scrutiny from policymakers at home and abroad, and they view trade deals as their best way of preventing new regulations against them. We've talked some about federal level legislation in these calls, but today we're going to focus in on what's happening at the state level. Nationwide, state legislators are working on bills to protect people from biased AI, online privacy violations, abuses of kids' data, and to guarantee consumers' right to repair electronics like phones, cars, or farm equipment. The surge in the last few years of these state legislation aimed at enacting protections shows that the American people want action on this issue. What a lot of folks don't realize is that big tech has a stealthy strategy to undermine that state level legislation, adding rules to international trade deals that limit how state and federal governments can regulate tech. Today, we're joined by Daniel Rangel and Katie Hettinga from Rethink Trade, who have been doing some incredible work connecting the dots between big tech's digital trade agenda and state level legislation. I'm going to hand off the mic in just a second, but I want to note that after their comments and a report back from Julie Bouanna about her work in Washington State, we are going to have time for questions. So please put those questions in the Q&A, and we'll get to as many of those as we can. Daniel, Katie, thank you so much for joining us. Please take it away.
Thank you, Hillary. Thank you for the invite to share our research today with everyone. I'm gonna share my screen, so if you can give me a heads up to make sure that people are seeing my slides, that would be great.
They look great.
Okay, perfect. So thank you again for the invite. I just want to start by giving everyone a little bit of a structure of how the presentation is gonna go. So first I'm gonna do an overview, very brief, of the digital trade agenda, where it started, when it started, and what are the main problems that we have identified with this set of rules, and what specifically happened during the Biden administration. And then I'm gonna ask Katie to walk us through a recent project identifying what Hillary mentioned, the specific state level policies that could be undermined by these digital trade commitments. So let's start by recognizing that the digital trade agenda emerged in a very different context regarding the tech industry in the US. And I don't have to say this to any of you guys, but if you remember around 2010, most people in the US, but also around the world, had kind of a positive view of tech platforms, and they were being perceived as innovative and all of these new resources that we had. And US policymakers had a very similar view of these companies. At the same time, the tech executives were skeptical of Washington politics. You wouldn't see people like Elon Musk or Mark Zuckerberg being in Washington every 2 or 3 months. And that all I would say, that started with the negotiation of the anti-counterfeiting trade agreement, the ACTA negotiations in early 2010, because through this agreement, platforms will have copyright obligations. And that meant that companies like Facebook and Google realized that trade agreements could be used to slip in certain terms and certain policies that will have a hard time coming through Congress or through state legislatures. And that's what many other industries have done before, like big pharma and the big agricultural businesses. So tech, in a way, caught on to that, and then they decided that they wanted their piece. And that's what we call, and they call, the digital trade agenda. Basically, they started trade associations in Washington. They started trying to get together with policymakers, and they developed this need for international rules on digital trade. If you look at that article of the American Prospect that I have there, and I'm happy to share the slides so you can click on it and go to the article. That article discusses research from a sociologist that basically explains how this is the case, how the digital trade agenda was actually an invention from the tech industry. So I really would recommend you guys to check out that story. So what was the first outcomes of this agenda? It all really started with the Trans-Pacific Partnership, which was concluded in 2016. As you know, the US abandoned this deal, but it was the main country that was proposing digital trade. Back then, they were included in an e-commerce agreement, but it really didn't have a lot to do with e-commerce, as we will see in this agreement. And all of the other countries kept that e-commerce deal with the rules that the US proposed, and now it's called the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CPTPP, and is the first big multi-party agreement that has these rules that the tech industry really favors. Then, well, as you know, the Trump administration started the renegotiation of NAFTA, and that meant that that was a new opportunity to include these digital trade rules in another US agreement. But the thing with NAFTA is that the new NAFTA is that the debate, there were a lot of things to discuss there. There were issues with labor, rules of origin for the auto sector, investment, state dispute settlement, environment, IP, you name it. So in a way, the digital trade chapter went under the radar, and it wasn't really on no one's side. That meant that by the end of the deal, the tech industry got what they themselves call the gold standard for digital trade. And that was also included in a bilateral deal with with Japan, that was negotiated in 2019. But this one was not ratified by Congress because it's considered an executive agreement. All of this meant that when Biden came into power in 2021, the tech industry wanted to get these same rules, the USMCA model, into other international agreements. Most importantly, the Indo-Pacific Economic Framework, IPEF, which was this negotiation that Biden started with many Asian countries, and our discussion launched by WTO members, around 90 members in 2019, about e-commerce, but again, is mostly about these digital trade rules. The thing is that, of course, many things have changed since 2016. Starting with the Cambridge Analytica scandal, the mounting evidence of anti-competitive behavior by big tech, all of the abuses of data privacy that we have seen by Instagram, TikTok, and all of these companies. Well, most people now are concerned about the outsized role that tech companies play in our lives. And the Biden administration, in its policy action, has reflected this new consensus. And this goes from the policy order on government-wide competition that has a special focus on big tech. There's active litigation against big tech companies like Apple, Google, Amazon. Additionally, the Biden administration 2 years ago issued a blueprint for an AI Bill of Rights and also an AI executive order that basically regulates how agencies use AI tools. And finally, there's also an executive order that limits data transfers to countries of concern. And this is without mentioning what has happened in Congress that approved a law that has a similar proposal that limits what data brokers can sell to countries of concern. That meant that last year, the US Trade Representative came out and said that we were changing our position on digital trade. First in IPEF, but this was not as well known, but then at the WTO, when in October in Geneva, the representative of the US came out and said that those proposals that were inspired by the USMCA, that's not what reflected where the US government is now. And a few weeks later, Ambassador Tai actually said that this change was important because keeping those proposals in will be massive malpractice or even policy suicide. And I think that that's very telling. And I think that that's also the perfect segue to go into the actual rules. So from our research, we have identified that these are the most important rules and those that are more concerning for the kind of like tech governance goals that Hillary was describing. First is a rule that's called source code that basically limits when and how governments can request access to software's code and algorithms. And I'm gonna go a little bit into more detail after this. But the second one is related to data transfers and storage regulation. And the third one is called non-discriminatory treatment of digital products. And here, this is someone that is more related to how this non-discrimination standard has been written, because it can actually be used by tech companies to challenge competition policies that affect big players. Is not part of our state project, but here, for instance, the worry is that the EU passed an act that's called the Digital Markets Act that labels certain tech companies gatekeepers and imposes certain obligations on these companies. And the US big tech companies have been saying that that's a violation of trade commitments and that it's discriminatory. So going back to the source code rule, as I said, basically this is a ban on having the government require access to code and also algorithms. The two main issues here is that algorithm is defined in a very lax way. So basically, the USMCA says that an algorithm is a defined sequence of steps taken to solve a problem or obtain a result. Many things can fall under this definition, and that means that there's secrecy over all of these things. And also, this rule has an exception, which is the second paragraph there, that establishes that the only situations in which a regulatory body, an agency, or a court could demand access to this kind of information is for specific investigations or enforcement actions or judicial proceedings. So if there are laws that establish general mandates so that companies have to disclose certain kind of information, well, that will be in conflict with this rule. And as we have seen in recent years, there's a call for algorithmic transparency and accountability. And this is because software and AI is in everything these days. It's not only the generative AI that has become very popular lately, it's also the hiring software, is the tools are used to determine how much do you pay for rent, or the tools are used in the criminal system, you name it. And there's evidence that these systems can be discriminatory or can be inaccurate. So that's why we need algorithmic transparency and accountability. And in order to achieve that, what experts proposed is that the developers of these systems have strong documentation requirements. They conduct pre-deployment testing of the algorithms before they go into the market. They have to test that they are accurate and not discriminatory, or even having third-party companies or third-party experts audit these algorithms. And in order to do that, of course, you need access to the algorithm and in some cases, the actual code behind it. And here you will see the conflict between that source code rule and where we're going with algorithmic transparency and accountability. And actually, at the state level, we have seen how many policymakers have proposed these kind of tools, and Kate is going to talk a little bit more about that. This source code rule is also related to right to repair, because very briefly, right to repair is basically a movement that has gained a lot of strength during the past couple of years that fights for the manufacturers of any kind of good, electronic products particularly, to be obliged to share information, tools, and parts that are necessary for regular people and independent repair shops to repair products. And when we're talking about electronic products, a lot of the things that you will need, like the repair software, the diagnostic software, or even the piece of code that allows you to pair a part with your device, that could be considered an algorithm. And in that way, a rule that determines that a government cannot require disclosure of these algorithms, then again, that will be all of these rules on right to repair will be inconsistent with such an international commitment. And very briefly, going back to the data issue, here we have two obligations. The first one is called cross-border transfer of information by electronic means. And here what's important to know is that this basically bans any kind of regulation that could limit the movement of data across borders. So this is not just the laws that determine that certain kind of data has to stay in a country. This is any kind of regulation that could have an impact on the ability of a business to move data from one country to another one. And second is the location of computing facilities, which is indeed the rule that basically bans governments from saying this kind of data has to be stored inside of the country or cannot go to certain places. And here in the report that I mentioned that I had there before, our international preemption report, we have some of the federal legislative proposals that could be undermined by this rule. But honestly, I think that the most interesting examples that we have in this specific area come from what state legislators have proposed and have actually passed. So I'm going to turn it over to Katie so that she can walk us through our research related to the state policies and how they will also conflict with these digital trade rules.
Perfect. Thank you so much, Daniel. And especially for that foundation that really grounds what we're looking at and how some of these state bills could be affected based on our current standing digital trade commitments. I'm also going to share my screen and get started here. First of all, an overview. As I'm sure we are all aware, the last couple of years, and especially this legislative session, have been absolutely huge for tech legislation, tech regulation proposals. There are hundreds and hundreds of bills just in the area of AI regulation, not to mention these other three areas that we focused on for our research that put some sort of regulation, whether it's data privacy, facial recognition, anything else on tech companies. I wanted to specify that for our research specifically, we dove into these bills and we took a look at the language and we searched specifically for legislative proposals that could be impacted by our digital trade commitments based on the terms that are included in the legislation. There's some really great information on our digital trade page, rethinktrade.org, and that I will share at the end of my presentation that gives you a deeper dive into some of the issues faced by both federal and state legislation. But I'm going to be focusing on what we found over these last several months. These over 100 state bills introduced in the last 3 legislative sessions that could be affected, challenged based on digital trade provisions. So like I said, you can see these maps and see what states are affected. It is the vast majority. 42 states and Washington, D.C. either already have bills on the books or considered in the last 3 legislative sessions legislation that regulates tech companies in a way that is inconsistent with our digital trade commitments. Looking at some of these areas specifically, we can truly see how much the efforts to regulate big tech's reach into our lives through social media, through the growing AI environment. We can see how all of these things are just continuing to expand, and we need state lawmaker and federal lawmaker action more than ever. And it's important to know how these bills may be impacted by the current international environment that we're operating in as well. Starting with AI regulation, we found 39 bills across 18 states, 6 of which have already been signed into law, that include provisions that may be inconsistent with digital trade commitments. I'll go into the language specifically so that we can see a couple of good examples of what we're looking for in these AI regulation bills. The primary conflict, as Daniel discussed earlier, is that AI developers for a lot of these pieces of legislation are required to share information about their algorithms. So whether it's their source code, sometimes it is the data that is used, their training data sets, the things that are used to actually build the algorithm with the existing data that they're pulling into the black box to train the AI systems. They have to share that information sometimes with the users or end deployers of the AI systems, sometimes with government regulators and agencies, sometimes with third parties, including independent researchers. And this often happens before deployment, sometimes as a condition for AI developers selling their system or providing it to another entity or person or company who will be using that AI. They have to transfer it over with the training information or other evaluations of the AI performance. So looking at 2 different states, first of all, my home state of Idaho, the Title 19, Chapter 19 of State Code concerns pretrial risk assessment tools. These are automated decision tools used in criminal trials, either by expert witnesses or for the jury to consider any risks that may be at hand with the defendant who is on trial. These automated decision tools, if they are used, per state law, must be open to public inspection, and specifically parties to criminal cases must be able to review these automated decision tools and find out how exactly it is ranking the final risk number that the defendant or other party is subject to when the tool is used throughout the trial. This is problematic because the documents, data, records, information that could constitute algorithmic information per our digital trade language. Another more recent example, in 2019, the AI regulation landscape was much different than it was in 2024. So now this year, Connecticut SB number 3, it was passed by the Senate and temporarily passed by the House. And this bill provided outlines for AI developers before they transferred their AI technology to another user, specifically for developers of what is classified as high-risk AI systems, definition of which is in the Senate Bill number 3 language. The developers of these high-risk AI systems must provide also documentation that describes the training data sets, which could be considered proprietary and could be at risk based on our current digital trade commitments. Moving on to kids' online safety. There have been 6 bills in 6 states, 3 of which already signed into law that we considered could present conflicts based on the current digital trade space that we're operating in. The primary conflict is that these social media companies, similar to the AI developers in AI regulation bills, must share algorithmic information with either government regulators or third parties, again, independent researchers, for audits to see specifically if their algorithms and online services that they're providing are harmful to minors that are using their services. Looking at two examples, one law passed in 2023 is the Texas SCOPE Act, Securing Children Online Through Parental Empowerment. These social media companies have to come up with a strategy to prevent minors' exposure to harmful material, also defined in the state statute. This strategy, as it says in subsection B, must make available the digital service provider's algorithm code. So the information about how the For You page is formulated and how this shows up on a child's screen. They have to provide that code to independent security researchers to see if there is risk of harmful material exposure. And another similar example, California's Age Appropriate Design Code Act, signed into law in 2022. Again, social media companies must provide data protection impact assessments, and they have to assess whether or not algorithms that are used to create the social media profiles and experience could potentially harm minors. These data protection impact assessments, if they were just completed internally and kept to the social media company's internal document retaining systems, that may not be problematic, but because there is language that says the Attorney General's office can request the data protection impact assessments, there is a risk of the social media company's information going to a third party, going to the government. And since that does not qualify necessarily with a specific government investigation or one of those very narrow exceptions that Danielle had detailed in the USMCA agreement, it may be problematic. And moving on to right to repair. This is only a growing movement. There are already 6 bills that have been introduced or on the books in the last few years. And with great organizers throughout the states, it seems like this is going to have some sticking power, and there will be more right to repair bills introduced in future legislative sessions. Over 36 states have considered the legislation, and 8 have already signed bills into law regarding the right to repair. So again, this comes down to sharing proprietary information and sharing algorithmic information with third parties. This time it is equipment manufacturers who may be required to share algorithmic information with the consumers or independent repair shops of their products. One of, if not the oldest example of a state right to repair law is the Massachusetts Right to Repair Act, which was signed into law in 2013. This bill specifically applies to motor vehicles, and at first glance, it may not sound like it is going to be a tech policy or something that we would have to worry about for a chapter called digital trade, but think about how many cars are internet connected. Think about how much technology and software there's used within the parts interacting with each other through motor vehicle operation. And some of these things, when you have to repair your car, sometimes you have to get the specific software information to be able to plug in the right headlight and get it operating with the rest of the vehicle system. This is one example of a product-specific right to repair law. On the other end of the spectrum, one example is Minnesota's Digital Fair Repair Act, signed into law last year. And this is a bill that also has the right to repair provisions requiring equipment manufacturers to provide information and specifically even embedded software information to the consumers or repairers of their products. This applies to all digital electronic equipment and parts for such equipment. Some other examples of product-specific categories range from powered wheelchairs to, again, motor vehicles, to agricultural equipment, to household appliances. So this is a wide-ranging issue that really touches specifically on consumer life, especially as we're using more and more digitally enabled and technologically advanced consumer products. And final area that we covered, switching gears a little bit, is looking at data privacy. 3 bills in Montana, California, and Maryland have been signed into law just in recent years that restrict sharing of cross-border data. And they do this for a couple of different reasons that I'll detail on the next slide. But these are implicated because there are not restrictions allowed for cross-border movement of data, even if it is for personal privacy or national security. So looking at personal privacy first, California and also Maryland has this very similar bill. California's Confidentiality of Medical Information Act was amended in 2023 to restrict companies and entities that host medical data, specifically sensitive data relating to reproductive health care, gender affirming care, contraception, abortion, these defined as sensitive medical services. It restricts that information from being shared outside of the state. California and Maryland have both billed this as personal protection, personal freedoms, privacy, but it is still at issue with our digital trade commitments. On the other end is the Montana Genetic Information Privacy Act. So genetic data collected in the state of Montana, whether that is an at-home DNA test like 23andMe or Ancestry.com, or a medical procedure that includes genetic mapping or anything like that that's collected within Montana, that information cannot be sent out and stored within the territories of U.S. foreign adversaries as defined by U.S. foreign policy. This is a national security concern that Montana state lawmakers brought forth to the legislative floor, and it is still something that there exists no exception that would allow for this law under our digital trade commitments as they stand now. As an overview for our interactive state policy tracker, I know that that was quite a lot of information and I am a pretty fast talker, but we have some really great resources that you are able to go and interact with and find details about your state, your neighboring states that I found very, very interesting, diving into all these legislative websites and reading so many of these bills. Those maps that I showed on our previous slides, they are on our website. You can click on each state and then scroll down and find a PDF fact sheet that we encourage you to share and utilize that has more details about some of the language in these state bills that we should be watching out for that may be at risk due to digital trade. And we also have an interactive database at the very bottom of the page. I'm going to share a link to it at the end of my last couple of slides that you can download the Excel, sort by state, sort by AI regulation, right to repair, the area of focus, and really drill down into what states may be impacted, even if they don't know it, by our current digital trade laws. I also wanted to note that we've only covered the last 3 years, 3 legislative sessions in our research thus far, but there are many more tech bills that are coming. As this Bloomberg Law article that just came out says, there were more than 400 state AI-related bills that were filed in 2024. I would bet there will be even more in 2025, and we are assuming that there will be more bills with language similar to the AI regulation bills and the other areas that we covered in our project that will be coming up throughout the state houses next year. So if you would like to learn more, we welcome you to check out the digital trade page of rethinktrade.org. It has both the reports that Daniel had shared earlier and also has our interactive state policy tracker. And I'll also drop links to the episode of the Rethinking Trade podcast with Lori Wallach. If you'd like to hear myself and Daniel talking about this issue a little bit more, you should listen to that podcast episode. And I'll also drop in the chat our governing op-ed, How Federal Trade Deals Threaten States' Crackdowns on Big Tech. Thank you very much.
Thank you so much, Daniel and Katie. I will note quickly for folks that I love a graphic that does a good job breaking down and helping folks digest data. And there was an incredible one that we had used for a long time on climate, but we had desperately needed a digital trade focused graphic like this for a couple of years. And so I'm really grateful, Daniel and Katie, for your research. We are going to have time for Q&A after Julie presents. So I want to continue encouraging folks to put questions in the Q&A. We are going to take time to get to as many of those as we can. Julie, do you want to share with us a little bit about the work that you're doing in Washington State?
Yes, I would love to. Hi, everyone. Thank you all for being here today, and for Hillary and the Trade Justice Education Fund for facilitating this really important conversation. Like Hillary said, my name is Julie. I'm with the Washington Fair Trade Coalition, which is a coalition of over 70 Washington and Oregon labor, environmental, consumer privacy, and other civil society organizations advocating for trade policies that work for people on the planet. So we've heard, about how big tech's digital trade agenda has the potential of impacting legislation across the country. And I just want to talk a little bit about specifically what that looks like in Washington and how we're fighting against it. So again, we have a really good context for the way that big tech is trying to manipulate trade rules to rig the system in their favor. So I won't go over that again, but I want to talk a little bit about how this agenda has serious consequences here in Washington. So in the Washington state legislature, policymakers are really starting to realize the outsized impact that big tech companies have on our society. And so, there's been kind of a slew of proposed and considered legislation to regulate big tech. And I'm going to talk about a few key pieces of legislation that could be impacted if big tech get their way here in Washington state. I'm not going to go into the ins and outs or anything, but just a quick overview, and then how these pieces of legislation could be impacted, and then what we're doing about it. So the first one I'll mention is the People's Privacy Act. It's SB 5643 or HB 1616 if you're interested. And this bill was introduced in Ames to give Washingtonians control over their personal data, specifically sensitive biometric data like fingerprints or facial scans. And if big tech's trade rules are adopted, corporations could essentially bypass these protections by transferring our personal data outside of US jurisdictions. There's also the Artificial Intelligence Oversight Legislation, SB 5356. And this law promotes transparency in AI decision-making and ensures that algorithms don't perpetuate discrimination, which we know that they often do. And big tech is pushing for trade provisions that would prevent regulators from accessing that key information and that key source code around how AI systems make decisions. So that would essentially completely block efforts to hold companies accountable for these discriminatory practices. And the last one, I'll mention that folks have talked about here on this call is the Right to Repair Act, SB 6276, HB 1933, and the bill guarantees that consumers can repair their own devices, from phones to farm equipment. But as we know, big tech's trade agenda would shield manufacturers from having to provide the necessary tools and information for repairs, making it harder for consumers to fix their products themselves or go to independent repair shops. So that's a little bit of context about some of the key legislation being considered and advocated for by Washingtonians in our state legislature, and how we know that big tech's agenda could threaten those pieces of legislation. So to talk a little bit about what we're doing about it, in September, a coalition of organizations came together to send a letter to Representative Susan DelBene, who's a ranking Democrat in the House Ways and Means Committee, urging her to oppose these harmful trade rules, basically. So it was a letter drafted by the Washington Fair Trade Coalition and signed by a broad coalition of 20 organizations across Washington and Oregon that really represent a wide range of communities and interests. So really incredibly broad coalition. We had civil rights groups advocating for stronger protections for marginalized communities. We had privacy advocates focused on ensuring that, individuals' personal data isn't mishandled or exploited. We had legal advocacy groups working to safeguard the legal rights of individuals in this evolving digital landscape and the criminal legal system. We had labor organizations that are worried about the way that AI and automation threatens workers' wages and jobs. Grassroots organizations trying to hold big tech companies accountable, community-based organizations pushing for equitable tech policy. So really an incredibly wide array of groups that came together on this issue to advocate for a digital future that prioritizes the rights of individuals over corporate interests. So our letter that we sent to Representative DelBene really calls on her to use her influence to stand up to big tech. And we know that she and other legislators, especially at the federal level, have the power to push back against these harmful trade provisions and defend our tech policies and Washington's progressive tech policies. So it's really crucial that we continue to apply that pressure and ensure that the voices of Washingtonians are heard. So if you're interested in checking out the work that we do, you can visit our website at washingtonfairtrade.org. And, in closing, I'll just say that I'm using Washington as a case example, but this type of work is going on across the country, from California to Texas to New York. And it's really, this big issue that folks are starting to really pay attention to. And, we know that this fight is far from over, but with such a strong coalition standing together, we have a real chance to protect our privacy, hold AI systems accountable, and secure our right to repair. And it's super important that we stay informed, engaged, and ready to push back against corporate overreach. So conversations like these are really important. So thank you again for taking the time to be here, and happy to answer any questions.
Thank you so much, Julie, for sharing about your work. It's really incredible, the groups of organizations that you managed to get together to work on this issue in Washington. I do want to flag quickly that MSN actually published an article covering Julie's work and covering the digital trade issue. I think Clayton is going to drop a link to that article and to share it on Twitter and Facebook in the chat in just a second. But would love folks help amplifying that message, amplifying that article. I also want to note as an additional action step that, like Julie mentioned, we're working on those letters in California, in Oregon, in New York, in Texas, and more. If an organization that you work with in one of these states is interested and wants to sign on to that letter, please get in touch with me right away over email. I think Clayton is also going to drop my email in the chat in just a second. But if you're interested in signing one of those letters, we want to be in touch with you as soon as possible. So I think with that, we are going to turn to Q&A. So one question that I wanted to pose, and I don't know, Julie, Katie, and Daniel, who wants to take a first try at this, but do you all think that state legislators are aware of the digital trade threat to the legislation that they're working on and that they're pushing for and holding hearings and it's quite a bit of work to get a bill over the finish line. Do you think that they're aware that there's the potential that these rules are going to swoop in and cause problems for their bill?
I can take a stab at that. Short answer, I would say no. And I think that is part of the reason why we are trying to build coalitions and build greater knowledge of some of these digital trade problems that may be posed to state tech regulation. I think that most people are probably unaware that there are these harmful digital trade commitments in our international trade negotiations and international trade agreements that are standing right now. When you think trade, you think tariffs, quotas, maybe if you've taken Econ 101, and if you have not sat through Econ 101 like myself, then you might just think like we're importing bananas, and that's all I'm really thinking about when I go to the grocery store. So when you get past some of these things that state lawmakers and anybody who's not in this space, there's a real information boundary, and I think that state lawmakers should be informed that these risks are posed to them, and I think I would welcome any ideas from the great organizers on this call on how we can increase knowledge.
Yeah, I would just add to that and say that that's my understanding as well. Just here in Washington, it's a hurdle that we kind of have to get over, is educating not only lawmakers, but also advocacy groups. I think there are these groups doing really, really important work here in Washington state around this legislation. And, an important part of our work is to also let them know, like, hey, look at all this important work that you're doing. It could all be for nothing, basically. And so a lot of the groups that we're advocating for this legislation are, the same groups that have signed on to this letter. And so, yeah, I think, a really important part of educating these legislators is also making sure that the groups that are pushing for this legislation also know about the threats. But yeah, I would say that is definitely still a priority and something that is still in need of being done definitely in Washington, across the country as well.
One thing that's been really interesting for me, just per your comments, Julie, is like the broad scope of things that the digital trade rules are touching. In terms of right to repair, like there's groups from all kinds of different backgrounds that ended up working on that, right? Like that outreach has led us talking to like waste management organizations and people that do waste-free focused work and environmental groups and tech groups and farm and ag groups, right? So there's just a huge number of groups that these bills kind of seem to touch. So it's really been interesting to see the coalitions around them and the ways that to think through a little bit the ways that those folks have some have the ability to talk with different state legislators about the specific things touching their issues. So one other question I got that I wanted to raise, and Daniel, I think this one is going to go to you. But if Katie or Julie have anything to jump in on, happy to hear that. If states, I understand basically that states used to be able to opt out of government procurement rules in trade pacts. Are states allowed to opt out of being covered by digital trade rules?
I think that that's a great question because you're right. In the end, trade rules can be designed in different ways to protect specific policy domains from being affected. And government procurement is one in which states have said, like, maybe we don't want to be covered by these rules as much as maybe what the federal government wants to do. In terms of digital trade agreements, there are certain agreements that don't go into government procurement, and that's something that is useful both for the federal but for the state level, but there's no exception for state policies. So all of these rules that we have been discussing about broadly air regulation, right to repair, data privacy, that's not government procurement. That's just regulating the economy in every state. So that wouldn't be covered by this exception. Hence, it will be covered by the rules, and it could be challenged under any kind of digital trade commitment, unless the agreements are negotiated in such a way that you leave state policy outside of them.
That's super helpful. I only have one other question, but if folks have questions that they would still like us to address, please go ahead and put those in the Q&A. Daniel and Katie, when we have had a past conversation about this, you talked a little bit about how this map that you put together has bills that you're sure about being in violation or in conflict with our trade rules, but that there are others that might be in conflict. I think my understanding is depending on how they end up being implemented. Could you talk a little bit more about that?
Sure. I'm just going to give an example that comes to mind, and then maybe Katie can complement. I'm talking about Washington State. A couple of years ago in Washington State, there was this proposal to tax the sale of personal data. Basically, lawmakers there said all of these companies are collecting swaths of personal data, then they're selling it and making a profit, and the people that are producing this data are not getting anything. So why don't we tax them? And in that way, we make sure that this business is actually contributing to people and the local economy. That kind of proposal eventually did not pass. It passed the committee phase, but it didn't go through because there was, of course, a lot of lobby against it. But that kind of proposal could be considered a restriction of the movement of data. So basically, you could have a business in another country that says, well, wait, in Washington State, they're going to tax me for selling data, personal data. That's going to affect my ability to move data across borders. And then that's a restriction. The trade agreement says that any kind of restriction of the movement of data is prohibited. Then I'm going to say that that's a violation. I'm going to try to get my government to attack that policy. That's kind of like how it works. Of course, it will depend on actually business being affected by this and these kind of policies being passed. But I think that there are all sorts of potential of proposals that have been made, but also a lot of things that we don't know how this economy is going to be regulated that could be affected by these digital trade rules.
Yeah, and I wanted to also add that there are some bills that the language is not necessarily 100% clear or specific because it requires expert government agencies to write the rules before they are implemented into state code fully. One example of that is an AI regulation bill that was introduced in Hawaii. And this bill prohibited the deployment of AI products within the state unless there was proof establishing the product's safety that was submitted to the Office of AI Safety within the Hawaii State Department of Commerce. So something like this, we're not sure what exactly would constitute affirmative proof that an AI product is safe. And since there may not be all of the details in a state regulation that are included in the original legislative proposal, we decided to not include those bills in the final product so that we could make it as robust as possible. But there are many other AI regulation and data privacy bills that when they're actually implemented and in effect, some companies may find some reason or attempt to sue the states based on how they implement the regulations. But as they were written, the bills that we were looking at on the legislative websites, we decided not to include in the final product.
That's super helpful. I'm going to address one more question quickly regarding whether or not we've done any outreach at the federal level. And I'm pleased to share that over the course of the educational work and the advocacy that we've been doing on this issue, we were actually able to get the Biden administration to withdraw some bad digital trade proposals at the WTO. And we were also able, through some advocacy last year, to keep some digital trade provisions out of the Indo-Pacific Economic Framework. So I'm very pleased to share that there's a lot of work going on at the federal level. But there is, this space in terms of state legislative authority and what kinds of regulations tech is going to be dealing with in different states. And I think this has been a really helpful framing for that. And like I said, if there are folks that want to be involved in letters in that space, please reach out to my email. So I think we are going to leave our Q&A there. And before we break today, I wanted to give a quick report back from our last Power Hour briefing. If folks were on last month, you heard us report about the new WTO attack that's been launched against the most significant climate legislation ever passed in the US, which is the Inflation Reduction Act. That lawsuit is a good example of why we cannot let big tech rig our trade rules the way that big pharma and big ag and big oil and Wall Street and other industries have been able to rig it in the past, because it can take years of organizing to undo the harmful corporate rigged rules once they're enacted. But the thing that I want to talk about right now is actually some good news. I'm really proud to report that since our last call, over 2,000 of you joined us in submitting official public comments urging the U.S. to oppose the WTO attack against the IRA, which is a huge, huge number of people to comment on an individual trade suit. So I just, again, want to say thank you so much to folks who submitted those comments. In addition, national organizations also submitted comments of their own. Citizens Trade Campaign, the Sierra Club, the United Auto Workers, the Steel Workers, the Machinists, the Carpenters, faith groups, consumer groups, and a bunch of others. The good news that I want to share today is that the Biden administration heard our calls and is actively opposing that WTO suit. They're fighting against it tooth and nail, and they've announced that they're doing so publicly. Whether they're going to take the next step and actively push for a climate peace clause to help head off additional trade attacks like this in the future is something that remains to be seen. And in my view, it's going to take a lot more pushing. Toward that end, I do want to mention an additional opportunity to advocate for a climate peace clause, and that's through a public comment period that's open now on what the US and the EU should prioritize in their ongoing trade negotiations. Just as some additional information, the US and EU both have their biggest climate initiatives ever being threatened with new trade challenges. Both blocs are among the biggest ongoing climate polluters, and both have historically pushed the trade rules that have gotten in the way of climate action. So these are the two biggest powers with an incentive and a responsibility to adopt a climate peace clause. We think that their ongoing talks are the most obvious place, right, for a climate peace clause to be initiated. So there's going to be a link in the chat in a second, which you can use to submit public comments as well. If you have already taken that action, thank you again. We are not going to let up on our demands that trade rules get out of the way of climate action and get out of the way of job creation programs. So I think that link is in the chat. Please sign that. And thank you again to the folks who submitted public comment last month on the IRA. I think it was really helpful in getting the administration to move. I wanted to note for folks that I am going to be in touch in the follow-up with all the links that folks have shared. And to be sure just that, you know, people have access to the tracker, that people have access to the public comment link in a written form if you want to be able to share that with folks. I do see one question in the Q&A, which I think would be an excellent way to close out this call. So Katie and Daniel and Julie, I'm going to put you on the spot, and I'm really sorry if you don't appreciate it. But this question says, can all the presenters give a quick 30-second elevator pitch that you'd like folks to take away from this meeting, to take back to groups that they work with? Daniel or Katie or Julie, do any of you want to volunteer to start on that?
I was typing something down to answer the question, so I'm just going to read what I was typing. I would say the tech industry lobby is fighting day and night to insert provisions in trade deals that will preempt key elements of privacy, AI, right to repair, and kids on life safety policies. State lawmakers must learn more about this stealthy preemption attack and fight back. And I will say, I will add to that elevator pitch to take a look at the specific state level fact sheets that we have on our website. And then you could add something about the specific policy from your state that could be preempted by this attack. I think that that's something that could make it very concrete for people, and that could get the interest of any kind of lawmaker.
Sweet. I can jump in and let Julie have the last word. My elevator pitch, I would say, tech regulation and tech policy is something that is proven is a very broad issue that has bipartisan appeal. There are dozens of states around the nation that have introduced tech regulation, hundreds and hundreds of bills just in recent legislative sessions, and we're going to keep seeing more of these bills proposed. It's important to pay attention and see how this digital legislation would affect you, your day-to-day life as a consumer or worker, and exploring more about how trade agreements can affect your day-to-day life in that way is vital if you are paying attention to the tech policy landscape in our country.
I'm gonna just tag on to that, both of those things, and just say that, you know, this is something that affects everyone. It affects so many communities and so many groups. Like, I think that's shown through the work that we've done. You know, you have privacy groups, you have like environmental groups, you have legal groups, you have like farmer advocacy, migrant advocacy, diaspora communities. I mean, this is clearly something that affects everyone. And, you know, I think if you bring this to people and you know, use the tracker that we talked about here, you know, the different policies that are being presented in the state, and also just like how tech impacts everyone's lives, that this is something that with a little bit of education is something that everyone wants to and is passionate about getting involved in.
That was so helpful, and thank you for the person that submitted that question. I think it was a great way to close out our call. I want to take a quick second to say thank you one more time, Katie, Daniel, Julie. Thank you for the research. Thank you for the outreach. Thank you for all the work that you're doing to move forward on this issue. Thank you to folks that were able to join us today. I am going to be in touch, like I said, in a follow-up email with a bunch of links and a recording of this call. I would love for folks to share that where appropriate. Thank you so much, everyone. Have a great afternoon.
Thank you.